the gift giving, the babysitting, the telephone extraction, the Google search at 2:27 in the morning, all of these, any one of these would be enough to dismiss the charges as they sit here today. But the cumulative effect of this deception and all of it, this distortion from the grand jury, is too much for the court to ignore.
What a case. A Boston police officer is dead and his girlfriend faces jail time for the crime, but she said she had nothing to do with it. Here's the case. Officer John O'Keefe was allegedly struck by Karen Reed's SUV on January 29, 2022, after a night of reported drinking with friends. Now, prosecutors point to evidence on her car's broken taillight to implicate Reed, but her defense says the damaged taillight came from accidentally backing into the victim's vehicle. Now, in the latest hearing ahead of Reed's trial, her attorneys pushed to have her charges dismissed.
That any distortion of the evidence, that's where we start, any distortion of the evidence during the course of a grand jury proceeding impairs the integrity of the indictment, if there is an indictment, and pursuant to Odell, that requires dismissal. In this particular case, there were myriad examples.
So here's Reed's defense. She believes there is a large-scale cover-up at play to protect other police officers involved in her boyfriend's death. According to prosecutors, after their night out, the couple was invited to a party at Officer Brian Albert's house. Now, Reed claims that she dropped off O'Keefe and turned in for the night, and when she woke up in the morning, he wasn't home. So back to Reed's theory, she believes that Albert beat up her boyfriend and left him to die. Now, one of the alarming pieces of evidence presented by the defense centers around Albert's sister-in-law, Jennifer McCabe, who was also at the party that night.
The Commonwealth suppressed one of the most obvious pieces of exculpatory evidence in the entire case, and that was a piece of evidence that they know torpedoes their entire case and their theory of this case, and that's Jennifer McCabe's Google search at 2:27 a.m., how long to die in cold. They had her phone at the time of the grand jury. They had her complete extraction of that phone at the time of the grand jury. They had a Celebrite report, Your Honor, at the time of the grand jury, and yet they did not present this evidence.
But the prosecution came to a different conclusion regarding the Google search evidence. Take a look.
Lastly, we get to the Google search, and I would agree with counsel in the sense that it's really no longer open for debate, but I'm not really sure why we're still even talking about this or why this is still a topic that they're pushing. Essentially, what we have is, yes, what counsel mentions is there is one expert who was given 2 extractions, presumably provided by defense counsel, that indicates from that particular FBI expert that the searches were done at 2-something in the morning. What counsel neglects to sort of raise and stress with the court is that there's a separate, and I forget exactly what it stands for, but an RCFL analysis of the phone in which through both Axiom and through Celebrite, and that conclusion of that expert is that the searches occurred when Ms. McCabe testified they occurred because the defendant asked her to conduct those searches at 6:23 and 6:24 in the morning.
So the defense had an opportunity to rebut this argument, and he came back swinging.
In regard to the Regional Computer Forensics Lab, that's the definition he couldn't remember, what they actually said was, because Mr. Lally got this wrong too, what they actually said was, yes, there was a 6:23 and a 6:24 search, and there was a 2:27 a.m. search as well. All 3 of those searches existed in the phone.
Reed's defense also says they have evidence to suggest something else really did happen to John O'Keefe.
Federal investigators hired, independent of us, we had no idea, and independent of the Commonwealth, hired a professional reconstructionist, 3 PhDs, to look into exactly this issue. Did Karen Reed's car, did her SUV make contact with John O'Keefe? And their conclusion to a person was his injuries were inconsistent with the damage on the car. The damage on the car was inconsistent with having made contact with John O'Keefe's body. In other words, the car didn't hit him, and he wasn't hit by the car.
Okay, so the defense claims that a conflict of interest is at the heart of this cover-up, one that traces all the way back to the lead investigator, Michael Proctor.
does that not show a bias, and how does that not implicate Karen Reed's constitutional rights to this information? And to this day, the Commonwealth has yet to concede what obviously is now sort of front page news, that there is in fact a personal relationship between the Proctors and their second family, the Albert McCabe family.
What kind of allegiance is the defense getting at here? Well, let's take a listen to what they say happened behind closed doors.
Cabes and Alberts ostensibly are one family. They socialize within the same social circle and the same familial circle, and that is who the Proctors have proclaimed to be their second family. And if that weren't enough, we find out during the pendency of this case on September 25th, 2023, that one of those family members, Jennifer McCabe, who's the subject of great interest in this case and a primary person of interest in this case, is invited to Trooper Proctor's personal home for some sort of off-the-books meeting. They've now admitted that Jennifer McCabe, a central character in the middle of this investigation, in the middle of this crime, was secretly meeting and or socializing with the lead investigator and or his wife in the living room of their home. And that, Your Honor, is a problem. And it shows more than a professional connection. It shows a personal connection. And according to the Proctor, the Proctor family's own counsel, Elizabeth Proctor's counsel, the subject matter of that meeting was commiserating about this case.
During the defense's motion to dismiss at a later hearing, they get into more detail about this purported bias.
On February 1st, 2022, 3 days after John O'Keefe was killed, there was another text message. And this one, Michael Proctor's sister texts Michael Proctor very specifically and writes the following, quote, "Just saw Julie, and Julie said when all this is over, she wants to give you, Michael Proctor, a thank you gift." Now let's fast forward 2 years later. Now Michael Proctor finds himself on the witness stand in front of a federal grand jury. And during that testimony, he was confronted with these and myriad other examples of evidence of his close ties to the Albert family. And he admitted to an AUSA, under very intense questioning, that not only does he know the Alberts, and does he socialize with them, does he drink with them, does he go to pool parties with them, but he told his partner, Yuri Butnick, all of this.
Despite this alleged conflict of interest, the prosecution disputes any evidence of a cover-up.
Suggestion of cover-up of evidence, no suggestion from the 13 civilians witnesses' testimony that we've received, or transcripts of that testimony. All of them confirmed that Mr. O'Keefe never entered 34 Fairview Road. All of it was absolutely no animosity between the individuals at the Waterfall Bar or at 34 Fairview residence. There was no fight, there was no dog attack, there was no eyewitness to the circumstances that led to Mr. O'Keefe's death.
Since there's no physical evidence linking any other officers to the crime at this time, the Commonwealth requested a protective order at a January hearing.
Hearing from me on behalf of Sergeant Buchanan and Trooper Proctor in a discussion as their privacy interests as it relates to the Commonwealth's motion for a protective order. The proposed protective order strikes a balance between protecting the sensitive and personal DNA information of two individuals who are not alleged to have had anything to do with the death of John O'Keefe.
But Reed's attorneys argued against that protective order, stating that the investigation is still underway, and so if more DNA evidence presents itself, it should be fair game.
Other evidence in this case where comparative testing, DNA testing could be done. Our investigation has been ongoing and is ongoing to this day. We may come into possession of evidence related to this case, physical evidence, that we may want to do our own comparative testing on. And once those profiles are released, assuming that there's consent and that the Commonwealth comes into possession of a DNA profile, and the defense does as well by Mr. Lally's admission today, that should be evidence that either side can use for any proper purpose that is case-related.
Defense attorney Yannetti says the investigation is ongoing, but we do expect to see this case go to trial next month. In the meantime, we'll wait for the judge's written ruling regarding the defense's motion to dismiss the case. Keep it here at Law and Crime for all the trial updates.